Hello everybody, welcome to iExamB. This is Amrita, your law faculty. In this video, I'm going to continue with the series of previous year questions from the subject of company law. Before I start with our discussion of these questions, don't forget to subscribe to our YouTube channel of iExamB exclusively for law subjects, for law exam preparations, and all legal updates that we keep on giving you, that is LegalB. And also visit our website www.iexamb.com for more details relating to all exam preparations. I have started a series of previous year questions from the papers 2020 and 2022, both phases, for Sebi Grade A Legal Officer examination. I have been discussing questions from constitutional law, contract, एंड इस वीडियो में हम लोग कंपनी लॉ का सेकेंड पार्ट डिस्कस करने वाले हैं. फर्स्ट पार्ट वी हैव ऑलरेडी डिस्कस्ड एज द सब्जेक्ट इज हैविंग अ वेरी गुड वेटेज इन एग्जाम एंड मेनी क्वेश्चंस आर आस्क्ड फ्रॉम दिस एरिया. इस सब्जेक्ट पर 2 वीडियोस बनाए गए हैं. इफ यू हैव नॉट वॉच्ड द फर्स्ट पार्ट ऑल्सो डू वॉच इट. अ सेट ऑफ 21 क्वेश्चंस हैव बीन कवर्ड and you will also find a PPT attached in description of all these videos. So don't worry, have a set of all these questions with you in the form of these PPTs. You can easily download them. Anytime you can refer and practice it. Also, all the mock tests other than this you will find free at www.iexamb.com. So वो भी visit करके check कर लीजिएगा and don't forget. Starting with the 22nd question. Board of Directors of a company shall exercise the following functions only with consent of the company by a special resolution. Now, according to this statement, you have to find out what is not correct in the following options. To sell, lease or otherwise dispose of the whole or substantially whole of undertaking of the company, invest in trust securities, what to be invested, amount of compensation that is received as a result of any merger or amalgamation, to borrow money where money that is to be borrowed with the money already borrowed will exceed aggregate of its paid up share capital, reserves and securities premium, to remit, give time for repayment any asset due from a director, all of the above. Now out of this, don't forget they are asking which is not correct. So the answer will be D, to remit or give time for repayment of any asset due from a director. As section 180, if you will refer, it is directly talking about this concept, to remit or give time for the repayment of any debt that is due from a director, and repayment of any debt that is due from a director. How they have carefully just made a change. This is asset and this is debt. So only one word has changed, but we often we don't notice that word. We skip it and हमारा आंसर गलत हो जाता है. Second, 23rd question. Such capital as is authorized by the memorandum of a company to be the maximum amount of share capital of the company is called as paid up capital, nominal capital, called up capital, issued capital, none of the above. Now the capital which is authorized by the memorandum of a company, that it is the maximum amount of share of the of capital of the company, is called as nominal capital of that company. And section 2 clause 8 directly talks about it. There are many direct questions from this act, but you have to thoroughly prepare it. That is what is the key. This is also known as authorized capital. So if you had an option of authorized capital also over here and a question was asked, so you should be aware that it is the same thing. What is the assessment here for newly incorporated company? If the company is incorporated before 1st day of Jan of that year, the assessment here will be starting from date of incorporation only, and it will end on 31st day of March every year. If the company is incorporated after 1st of Jan, then assessment year shall be starting from date of incorporation ending on 31st March. Company is incorporated on 29th November. Assessment shall be from 1st April to 31st March 2022. If company is incorporated on 1st day of Jan, assessment year shall be starting from 1st April, none of the above. 1st April of the following year, none of the above. Now what is the correct answer? Now for this you should be very clear in your concepts that how you can calculate an assessment year of a newly incorporated company. If your concept is clear, you can easily answer the question, and the correct answer is D. If the company is incorporated on 1st Jan or any time after that, then the assessment year shall be starting from 1st April of the following year. Section 2 clause 41 of the Companies Act says that first financial year of any newly incorporated company or body corporate shall be starting from the following year only, that is 1st April. That is assessment year. So assessment year AY after it comes after the financial year. If they ask you financial year, then that also you should be able to answer. Startup companies with the potential to grow need a certain amount of investment. Wealthy investors like to invest their capital in such kind of businesses with a long-term growth perspective. Now, what is this capital known as? Again, a question from capital. Answer is D, venture capital. Venture capital is required. It gives a potential to the company to grow, and that investment which it requires initially, that is what is venture capital. So you can know more about it. You can stop this video also, or you can simply download the PPT and revise all these concepts. With respect to the appointment of proxy to attend and vote at a meeting on behalf of any member of a company, consider the following statements. Now, question from proxy. Proxy has right to speak in meetings. He shall not be entitled to vote except if there is a poll. Proxy can act on behalf of any number of members. Instruments that is appointing a proxy can be oral or written. All the statements are false. Now the answer is B. Proxy shall not be entitled to vote except on a poll. Now what is the most appropriate one that you have to select? Section 105 you can refer for that purpose. It talks about proxy, what proxy can do. He can attend and vote. He shall not be entitled to appoint any person as a proxy, any member, and that proxy has to attend and vote at the meeting on his behalf, provided that proxy will not have right to speak. He shall not be entitled to vote except on a poll. Except with the consent of the board of directors given by a resolution at a meeting of the board and subjected to such conditions as may be prescribed, no company shall enter into any contract or arrangement with a related party with respect to sale, purchase, supply of any goods or materials, leasing of the property of any kind, appointment of any agent for purchase, sale of goods, services, materials, underwriting the subscription of any securities or derivatives, all of the above. The answer is E, all of the above. All of the above statements will be correct in this matter, and you can refer section 188 of Companies Act 2013. If the quorum is not present within half an hour from the time that is appointed for holding a meeting of the company, the meeting shall stand adjourned to next day, next week, same day in the next week, same day in the next month, none of the above. So that adjournment of meeting for lack of quorum will be standing to the same day only, but that will be in the next week. Section 103 of the Companies Act again is important, and you can refer for that purpose. Which of the following is not a method by which one person company with one director can raise money? Venture capital, financial institutions, angel investors, issue of shares, all of the above are valid methods. Now, which is not a method by which one person company with one director can raise money? Answer is D, issue of shares. So issue of shares cannot be used for raising money. That is not possible because it is a one person company, one OPC. It can raise funds through all the other modes: venture capital, financial institutions, angel investors, etc. And issuing of shares is not possible because it is the core principle is that if you it will be violated if shares are issued. What is the minimum age of a director? 22, 21, 35, 45, 18. Answer is B, 21 years. As per Companies Act section 196(3) subclause A provides the minimum age of a manager, managing director, whole-time director. All of them should not be below 21 years and should not be more than 70 years or more. इससे पहले भी एक क्वेश्चन आया था, it was relating to 70 years maximum age. अभी यहाँ पे आया हुआ है minimum age. तो ऐसे क्वेश्चंस के लिए अभी आप prepared रहिए. A copy of memorandum of association, article of association can be given to the members on request within 14 days of request, 7 days of request, 30 days of request, 21 days, maximum of 2 months of the request has to be given. Again, answer is B, 7 days of request. MOA, AOA, these topics, there is no doubt indeed ये बहुत important है. It is very important for you. कोई भी तरीके का क्वेश्चन आप एक्सपेक्ट कर सकते हो. Section 17 talks about this particular provision. What is the notice period for the annual general meeting of a company? 21 days, 20 days, 30 days, 60 days, 90 days. Now these questions are of such a kind that if you know, you know. If you don't know, you don't know. So for this you have to study and remember it. 21 days is the notice period of the annual general meeting that has to be given, and it can be given in any mode, writing or in electronic mode. First meeting of a company is held within how many days of its incorporation? Now that is held within 30 days of its incorporation. 30 days of incorporation में ही first meeting hold हो जाती है. Again, a very important concept. Even if you have seen the answer directly, don't forget, focus on what is important. Technical glitches होते ही रहते हैं, but what is important, the question and from where it has come, that is important for you at this moment. So section 173 clause 1 of Companies Act you have to read for this matter. DIN is allotted to a director of a company by whom appropriate government, state government, central government, company law board, promoters. Now DIN is allotted by whom? Director gets his identification basically. So that is given by the central government, and section 154 talks about this particular provision. अब आपको ये भी आ सकता है कि कितने टाइम में मिल जाता है. So that has to be done within 1 month from the receipt of application under section 153. For that, application has to be made और director identification number दिया जाता है 1 month में. In case a company makes a default in transferring shares to the IEPF fund, such company shall be liable for a penalty of 1 lakh rupees, 1 lakh rupees subjected to a maximum of 10 lakh rupees. 1 lakh rupee if there is continuing failure, then further penalty will be of 500 rupees for each day and subjected to maximum of 10 lakhs, not less than 5 lakh but may extend to 25 lakh, not less than 10 lakh but may extend to 25 lakh. So the answer is C, 1 lakh rupee. If there is continuing failure, then there will be a further penalty of 500 rupees for each day subjected to a maximum of 10 lakh. This is provided under which section? It is provided under section 124 clause 7 of the Companies Act. A company may issue full paid up bonus shares to its members in any manner whatsoever out of its free reserves, if the securities premium account, capital redemption reserve account, A and B only. A, B and C all are correct. Now this is talking about fully paid up bonus shares to its members that a company can give. It can be given out of where? It can be given out of all of these funds, these accounts: reserves, free reserve, securities premium account, or capital redemption reserve account. Section 63 of the Companies Act 2013 is important and it deals with this aspect. And this is also provided that no issue of bonus shares shall be made by capitalizing reserves. So अगर यहाँ पे capitalizing का भी option आता है तो you should be very clear with it. Which of the following statement is true about red herring prospectus? Red herring prospectus is issued by a company proposing to make an offer of securities, issued to attract different investors, issued prior to issue of a prospectus. Both A and B are true. All of the above are true, A, B and C. Now red herring prospectus, we all know it is a very questioned area from company law. So the answer is all are true. It can be issued by a company proposing to make an offer of securities. It can be made, what is the objective? To attract different investors, and it has to be issued prior to issue of prospectus. So we know all these three things are very true about red herring prospectus. Section 32 of Companies Act deals with the issue of red herring prospectus. When a company needs additional capital and keeps the voting rights of a shareholder proportionally balanced, then the company issues rights shares, issues red herring prospectus, issues a prospectus, issues bonus shares, it issues debentures. Now here concept clarity. As I am telling you, some questions are knowledge based, direct, section based, and some are concept based. So if you are having a good concept clarity, you can score very well and answer these questions. Answer is issues rights shares. Now further issue of share capital, section 62 talks about the issuing of rights shares. It is talking about where at any time a company is having a share capital that is proposed to increase its subscribed capital by issuing of further shares, such shares shall be offered to persons at the date of offer if they are holders of equity shares in proportion as nearly as circumstances admit to paid up share capital on those shares by sending a letter of offer. Sweat equity shares cannot be given to public at large, employees, directors, either to employee or director, both to public at large and employees. So sweat equity shares concept cannot be given to public at large. This is what is the concept. Section 2 clause 88 of the Companies Act deals with sweat equity shares that are issued by a company. It is issued to its directors or employees, and it is issued as a discount, at a discount. Which is the appellate tribunal for hearing appeals from the orders of National Company Law Tribunal? This question has come earlier also. Very easy question. National Company Law Appellate Tribunal. This is provided under section 2 clause 4 of the Companies Act only. That what is appellate tribunal. Who can authenticate the documents that are filed by a company to the registrar? Registrar only can do that. Directors can do that. Orders of the company can do that. Both A and C, that is registrar and auditors of the company, any person can do that. Answer is directors. Only directors can authenticate the documents that are filed by a company to the registrar. This is provided in Rule 8, Authentication of Documents of Companies, Registration Offices and Fees Rules 2014. यहाँ से ये क्वेश्चन आया था. थोड़ा सा practically important question हो जाता है ये, and that has come from rules. So you have to be aware of such kind of things also if such kind of questions are asked. And यहाँ पे थोड़ा सा आपको आपका कभी कभी आपको नहीं पता होता है, you have not read these rules at all, तो कभी कभी आपको थोड़ा सा अपना लॉजिक भी अप्लाई करना होता है at that particular time when you are solving the questions. एक हाथ दो क्वेश्चन ऐसे आ ही जाते हैं, you can expect that. So don't panic, we can expect. It is a competitive examination. As per the Companies Act 2013, a non-profit organization can get itself registered without addition of the word dash to the satisfaction of the central government. Section 8 company, Section 25 company, private limited company, Either A or B, all of the above. Now this is talking about non-profit organization, how it can get itself registered without addition of the word private limited company to the satisfaction of the central government, and private limited of course does not apply. सेक्शन 8 कंपनी है ये ज़रूर, बट वर्ड कौन सा नहीं अप्लाई करना है, प्राइवेट लिमिटेड अप्लाई नहीं करना है. If the articles of the company does not provide for the appointment of the first director, then dash shall be deemed to be the first director of a company. This is very easy question. Those who are subscribing to the memorandum, all of them will be the first directors of the company. Section 152 talks about appointment of directors. If it omits to mention, then the first directors will be subscribers of the memorandum. Every company shall have at least one director who stays in India for a total period of not less than 182 days. Now, which time period? The answer for this will be as per section 129. A company has to have board of directors. Every company shall have at least one director who stays in India for a period of not less than 182 days during the financial year. So the correct answer will be during the financial year, that is option A. When can debentures be converted into shares? At any time, at the time of redemption, before the time of redemption. There is no such option available that when a debenture can be converted into a share, at the discretion of the debenture holder. So the correct answer will be B, at the time of redemption. Section 71 of Companies Act talks about debentures. Again, a very important topic from company law. Company may issue debentures with an option to convert such debentures into shares either wholly or partly at the time of redemption, provided that issuer debentures with an option to convert such debentures shall be approved by a special resolution that is passed by at a general meeting. So the answer is at the time of redemption. So these were all the questions from the subject of company law, divided into 2 videos, and the video I hope will be very beneficial for you. So do practice all these questions, and also you can come to us with any of your queries and requests. We are expert faculty for legal at IEPF. Myself, Amrita Johar, Miss Neha Dubey and Miss Vidika Bansal. We all are here to help you. If you are having any queries, you can write to us in the comments of this video as well. Also, don't forget to visit our website and check out all the courses that are available online, not only for Sebi Grade A legal exam, but also other law officer examinations, other examinations, RBI, Sebi, NABARD, Coal India. We have so many examinations that we provide coaching for online. And also don't forget to subscribe to our YouTube channel and prepare 50% faster with iExamB. Thank you so much.